Hello everyone and welcome to this video tutorial on insanity. Insanity in English law is a defence to criminal charges based on the idea that the defendant was unable to understand what he was doing, or that he was unable to understand that what he was doing was wrong. The defence of insanity is a general defence which is available to all crimes. Where a defendant is found to be insane, the jury are directed to give a special verdict of not guilty by reason of insanity under Section 2 of the Trial of Lunatics Act 1883. This previously meant automatic admittance of the defendant to secure accommodation, and release was only possible on authority of the Home Secretary, and this often resulted in lifetime institutionalisation. Mandatory detention still applies where the penalty for the offence is fixed by law, such as murder, but in all other cases, detention is at the discretion of the judge under the Criminal Procedure Insanity Act. And a judge can now order hospital orders, guardianship orders, supervision and treatment orders, and even absolute discharge. The defence of insanity is unique in that it may be raised by the prosecution and the judge in addition to the defence. Indeed, it's generally the defence seeking to avoid a finding of insanity, and often the defendant will change a plea to guilty just to avoid a finding of insanity. However, the defence has declined in importance over the years since the abolition of the death penalty and since the introduction of the defence of diminished responsibility in relation to murder. The rules on insanity come from an ancient case called Macnaghten from 1843. And the facts of this case were that Daniel Macnaghten attempted to kill the Prime Minister, Sir Robert Peel, but instead shot and killed Edward Drummond, the Prime Minister's secretary. Macnaghten was suffering from insane delusions at the time of the killing. The House of Lords formulated the Macnaghten rules, which apply in determining whether a person should escape criminal liability on the grounds of being insane. In his judgment in the case of Macnaghten, Lord Tyndall CJ said that in all cases of this kind involving insanity, the jurors ought to be told that every man is presumed to be sane and to possess a sufficient degree of reason to be responsible for his crimes until the contrary be proved to their satisfaction, and that to establish a defence on the grounds of insanity, 3 requirements must be proven. So the 3 requirements for establishing a defence of insanity are that it must be clearly proved that at the time of committing the act, the defendant was labouring under such a defect of reason from a disease of the mind so that he didn't know the nature and quality of his act he was doing, or he didn't know what he was doing was wrong. I have just summarised those Macnaghten requirements slightly differently as a diagram here for you. So we have to show defect of reason caused by a disease of the mind, and then there's 2 options. Your defendant doesn't have to not know both of these, just one of them will suffice. So a defect of reason by a disease of the mind so that the defendant doesn't know the nature or quality of his act, or doesn't know that the act was wrong. Now, we've come across nature and quality of his acts before when we've been looking at the defence of diminished responsibility. So this means your defendant doesn't know what he's physically doing. So, for example, he might be chopping up a head thinking it's an orange. In that situation, he wouldn't know the nature and quality of his acts. In other situations, though, your defendant may know what they're physically doing, but they don't know it's wrong because, for example, they think maybe God is telling them to do it, so they think it's the right thing to do. So, before we look at each of the requirements in turn, I want to talk to you about a case called Harris from 2018. And this is just quite a nice example of how the 3 requirements from Macnaghten work. Parts of this case are really shocking because it involved our defendant, a mum called Carly Ann Harris, who was 38, who drowned her 4-year-old daughter, Amelia, and then set her body on fire on a patio table in the garden. And Mrs. Harris was found not guilty by reason of insanity because she believed she was sacrificing her daughter in order to save the world. During the trial, psychiatrists for both the prosecution and the defence agreed that Harris had paranoid schizophrenia. Harris was suffering from delusions that Amelia was actually a fallen angel who needed to be sacrificed in acts reflected in the Old Testament, i.e. drowning and then burning, in order to return Amelia to heaven in order to save the world. Amelia's body was tragically found under a sheet by her teenage brother on a table in the garden. The police were called, and when the police arrived, Harris told the police, "Don't worry, God will be with her. The angels have taken her. Don't worry, the angels told me to do it. It's okay." The jury in this case took just 1 hour to find Harris not guilty by reason of insanity, and the judge imposed a hospital order. Of the requirements for insanity then, you can see here that Harris was clearly suffering from a defect of reason, from a disease of the mind, and in this particular case, she knew what she was physically doing because she knew she was drowning and burning Amelia. However, she didn't know what she was doing was wrong because her schizophrenia had made her believe that she was actually doing the right thing and she was saving the world. Now that we've looked at this example of a fairly recent insanity case, we're going to break down and have a look at each of the requirements for insanity, starting off with defect of reason. Finding of insanity, the defendant must suffer from a defect of reason. This is requirement 1. And the case of Clark tells us that mere forgetfulness or absent-mindedness is not sufficient for a defect of reason. Because short periods of absent-mindedness, we all might experience that from time to time. It's not going to be enough for insanity. The requirement for insanity is that the defect of reason was caused by a disease of the mind. Now, this terminology is very misleading because disease of the mind makes you think of mental conditions such as schizophrenia, which of course, as we've just seen, can lead to a finding of insanity. But really, disease of the mind just means any disease which affects the mind. And we're going to see that through some cases now. If we have a look at Kemp, our defendant here was suffering from a condition called arteriosclerosis, and this means hardening of the arteries. And we've got a diagram here. So this is where it might be because the arteries are clogged up, but his condition meant that from time to time, his arteries would be restricted and close, reducing the amount of blood flow to his brain. And this meant that he often blacked out. And on one particular occasion, when he blacked out because he wasn't getting enough blood and therefore oxygen to the brain, he attacked his wife with a hammer. Now, he argued he didn't want to be found to be legally insane. He said that he didn't have a disease of the mind for insanity because he had a physical illness, i.e. arteriosclerosis was a physical illness, not a disease of the mind. But unfortunately for him, this argument didn't work. What the court said was a physical disease, such as arteriosclerosis, can be a disease of the mind if it affects the defendant's ordinary mental faculties of memory, reason, and understanding. And those 3 key words are really useful to use in the exam. So you can see here by using these 3 words that any physical condition, say for example if someone has a brain tumour, for instance, that's a physical condition, a tumour in the brain, but if it is affecting their memory, reasoning and understanding, it can therefore be a disease of the mind. On this same point is the case of Sullivan, and here our defendant kicked the victim whilst he was having an epileptic episode. And the defendant often showed aggression during his epileptic episodes. And the court ruled here that epilepsy can be a disease of the mind for insanity because when someone is having an epileptic episode, their faculties of memory, reason, and understanding are impaired. And I think these cases are showing how insanity is not really a defence that the general public expect that it is. I think most people would be surprised that epilepsy can be a disease of the mind for insanity. We tend to think of it as being schizophrenics, not people suffering from common conditions such as epilepsy. Then got the case of Hennessy, and our defendant was a diabetic who hadn't taken his insulin for 3 days. And during this time, he was suffering a bit of a blackout caused by not taking his insulin. And he took a motor vehicle without consent and driving it whilst disqualified. And he had no recollection of taking or driving the car because he was suffering from a diabetic state at the time. The court said that diabetes can be a disease of the mind for insanity, but importantly here, this is only if they have not taken their insulin. We're going to find a slightly strange rule later that if they have taken their insulin, that's an external cause and that will be a different defence. But if they've not taken their insulin, it is their diabetes which is inside them, which has caused them to get into this state. So therefore it can be insanity. In the case of Burgess, it was held that in some instances, sleepwalking can fall within the definition of insanity. So if a person is sleepwalking because they have some sort of condition which causes them to sleepwalk, then that would be classed as a disease of the mind for insanity. If, however, they were hit on the head by a stone, that would be an external cause, and that would be something quite different. And that leads us on to this next slide here, where we need to consider these external factors. So we've already considered a diabetes case, Hennessy. We always need to contrast that with the case of Quick. And in Quick, our defendant was a diabetic who had taken his insulin, but hadn't eaten enough afterwards. And this caused low blood sugar, which will affect the brain. And he was a nurse at a mental hospital, and during this diabetic state that he was in, he assaulted a patient. Now, the court said here that diabetes caused by taking insulin is an external factor, so that would be the defence of automatism, which we will look at in a separate video tutorial. So the reason for this, it seems really odd, I know, but if they don't take their insulin, we're saying the diabetes inside them has caused the diabetic state, internal insanity. Whereas if they have taken it, they've injected themselves, then we see the syringe as being an external cause, something they've brought into the body, and therefore it's not inside them. It is an external factor, it's automatism. So depending on whether your diabetic state is caused by not taking your insulin or taking it, will result in a completely different defence being available, which of course is ridiculous and has been a major criticism of the defence of insanity. The final requirement for insanity is that the defendant either doesn't know the nature and quality of their act or they don't know it was wrong. So for not knowing nature and quality of their act, this could happen in two ways. Firstly, they're in a state of impaired consciousness. So that would be defendants such as Kemp and Hennessy, whereas due to their physical conditions, they're having blackouts, so they're not conscious of what they're physically doing. The other situation is where they're conscious, but the mental condition means they don't know what they're doing, such as classically the Katie Ruff killer, or the case of Oy, which we will look at here. In Oy, our defendant attacked the police, believing them to be demons and agents of the devil. He drank out of a toilet, believing it was a beautiful stream. Here, he's not unconscious, but he clearly doesn't know the nature of his acts if he's thinking this water is a beautiful stream. The alternative, if they do know what they're physically doing, is not knowing the act was wrong. And we've seen that already in Harris. She clearly thought she was doing the right thing by sacrificing her daughter. In the case of Windle, the defendant's statement that I suppose they will hang me for this proved that he knew what he was doing was wrong. And because he also knew what he was physically doing, he was unable to plead the defence of insanity.